Hi everyone, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Today, we're answering the question, what is a trust? A trust is an agreement providing instructions as to how one person or entity is to hold and manage property for the benefit of another person or entity. Ready to learn some legal words? The person who creates a trust is called a grantor. The person who holds and manages trust property is called the trustee. And the person who the trust property is managed for the benefit of is called the beneficiary. Depending on the type of trust, you could be named in all 3, 2, or 1 of these roles. There are a number of different types of trusts, and one trust can have multiple sub-trusts within it. So as you might be starting to realize, it is a very complex area of the law, and there's way too much to cover in a short video. So this video, I'm only going to briefly explain 2 types, a testamentary trust and a revocable living trust. Testamentary trusts are trusts that are written into wills. So everything in my What is a Will video applies. As a quick overview, wills do not become effective until after your death. The will has to be filed on public record and your assets go through the probate process. If you want to learn more about probate, check out my video, What is Probate and Should I Avoid Probate? But quickly, probate is the court process of getting assets to the individuals legally entitled to them. That process typically takes about a year or more. Revocable living trusts are effective during your life, during any time of incapacity or disability, and after your death. They are similar to wills in that they set out the disposition of your assets after your death. But one critical difference is that a fully funded revocable living trust avoids probate. The trust does not have to be filed on public record, so it's a completely private document. The successor trustee can act immediately and won't have to go through the probate process if all of your assets are fully funded. Okay, I've said it twice now. To avoid probate, the revocable living trust has to be fully funded. But what does that mean? Funding a trust means actually putting assets into the name of it. For example, retitling accounts in the name of the trust, deeding your real estate into the trust, and changing beneficiary designations to the trust. Funding is very important. Without properly funding your revocable living trust, your assets have to go through the probate process before being put into your trust and distributed per those terms. If that happens, then your revocable living trust is acting more like a testamentary trust. If you have a revocable living trust, you should also have what is called a pour-over will to catch any assets that were not funded into your trust at your death. As the name implies, it pours over those assets into your revocable living trust to be distributed per those trust terms. However, the goal is to properly fund all of your assets while you're living, so your assets don't have to go through that pour-over will and the probate process. There's a lot of information in this video, and I've only breached the surface of trusts, but that's going to be it for today. I hope you liked this video and found it helpful. Please share with anyone you think needs to hear it. Again, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Have a great day.